Morning, may I please the court, Phil Talmadge and Amanda Searle here representing Madeline Barlow. Madeline was an incoming freshman at Washington State University, Pullman, who was brutally raped by Thomas Culhane, a WSU upperclassman, with a history of 3 prior incidents of sexual misconduct while at Washington State University's Vancouver campus. Culhane was on probation until graduation for the second and third of those incidents when he raped Madeline.
I think the reason I asked that is a general matter. You're trying to develop a relationship and a responsibility between the university where we are and its students, and a duty based upon that relationship. So how would you confine that rule of law that you would ask us to embrace?
Well, Your Honor, I think that in response to the questions the Ninth Circuit has posed, they asked first, is there a special relationship? And the answer to that is yes. And candidly, I think both the WSU and we agree that there should be a special relationship. The question is the scope of the duty that arises from such a special relationship. We've argued that, in fact, the special relationship should be a predicate for a duty based on the special protective relationship as to a student, and as to the take charge type duty as to the perpetrator, or some combination thereof, as this court determined in CJC that you authored. Any one of those 3 bases, or in addition, the requirement under 302B of the restatement to refrain from enhancing the risk to a student, could also be a basis for such a duty, limited by the principles of foreseeability. Yes, Your Honor.
Previously, our Court of Appeals has looked at this issue and has declined to find a special relationship based solely on the relationship between the student and the university.
Okay, so did you guys hear that, right? Previously, the Court of Appeals has already found that there is no special relationship between Washington State University and one of their students. Okay? Good morning, everyone. Welcome in. We're doing this a different way. I'm so very sorry. It is what it is. You don't get video. You're only getting the fucking audio today, friends. Okay? Sorry. The video is linked in the description. Jazz King, hello, my king. Welcome on in. Jackie H, hello. Jackie B, hello. Esther Hahn, hello. Okay, welcome on in, everyone. Welcome, welcome. Trying to figure something out here real quick, and then what we're gonna do is I'm gonna let this play, okay? It's only about 15 minutes of oral argument. We're gonna let it play, and then we'll talk about it, all right, friends? If you can't hear it, I have their volume as high as it can go. You're gonna have to put in your earbuds or some shit, all right?
And yet there are other duties that fall on the university, such as obviously a landlord or premises liability, that sort of thing. So what has changed in your mind and in what we should be considering that would suggest we abandon that approach?
Well, you're speaking to the Johnson case, Your Honor, that Court of Appeals decided, and the events have long since passed what Johnson, the basis for the Johnson decision. Circumstances have changed dramatically since that time. One thing, we have this epidemic of sexual violence that's occurring in connection with higher education in Washington. It prompted the legislature to adopt a statute, 28B 112. The legislature recognized that there was a serious problem that had to be addressed, and each one of the public universities, as well as most of the private universities, have adopted counterpart regulations to deal with the problem of sexual violence on campus.
But counsel, does that mean that the basis of the duty has changed or needs to change?
Yes.
And so being the premises responsibilities does that not include taking care when there is alcohol or when there are mixed genders residing together, such things?
The point that I was going to make was that the circumstances have changed dramatically since Johnson, both in the law, I mean, as the legislature, the Clary Act, Title IX at the federal level, all of those changes. But the reality of what's going on campus, the appreciation of the scope of the problem, this epidemic of sexual violence, is really significant. It's really demonstrably
Can I
different.
push back on that for a second and consider the possibility that this epidemic has been going on all along? It's just that we're now facing it and trying to do something about it. So isn't the change more how we view it rather than an actual increase in the incidence?
I'm not sure that that's necessarily the case, Your Honor, because the data from Washington State University itself indicated an uptick both in terms of on-campus sexual violence and off-campus sexual violence associated with the activities of students.
And I'm just wondering if it isn't that the incidents have increased, but the reporting of them has.
You notice the one thing that this lawyer isn't bringing up, the guy doing the oral arguments here. You notice the one thing he's not talking about, because as you can see from the date on the screen, this hearing was held February 23rd, 2023. This is after WSU police officers have had to resign for their grooming and sexual assault and covering up of those things by their own police officers. So all of these justices and this guy doing these oral arguments are very well aware that actually not only have the claims of sexual assault on campus skyrocketed, but they're also fully well aware that this is happening after their own police have had to resign due to their illegal trysts with students. Very interesting. Very, very interesting.
Certainly, the Clery Act, Title IX, the federal requirements have made it a more open reporting situation, but you also have very clear-cut information that the amici provided the court indicating that underreporting of sexual violence is a phenomenon that the court should not be oblivious to. Students avoid reporting sexual violence because it's uncomfortable, it's difficult, and they feel that the universities are often very, very slow and not very supportive in responding to their concerns. Not to be lost sight of in this particular case, QR, who reported the violence, 2 separate incidents as to Thomas Culhane, waited 10 months for that process to unfold before something finally happened at Washington State.
Well, maybe many of the students are also afraid to report their sexual assaults because the fucking police are also assaulters and groomers. Maybe, just maybe, it's just my opinion, just throwing it out there.
Earlier about, ask you a little bit, see how far that your argument would take us. If one of the students here walked over to Starbucks and was sexually assaulted, and there was a general idea that in this neighborhood that's a regular occurrence, would the cause of action lie? And if it wouldn't, what would be the limitation that would prevent that?
The normal limitation, Your Honor, in a tort setting is foreseeability. And also, if it happened at Starbucks, the question is, who was the perpetrator? In this particular case, you have a circumstance where you have both are Washington State University students. Madeline lived in a residence hall at Washington State University, albeit only for 4 days that she was first on campus. And Culhane was an upperclassman at Washington State University. Did the violence at that Starbucks incident occur with respect to a third party who was not a Washington State University student? Liability for Washington State would probably not fall under principles of foreseeability. 2 university students, one of whom was under probation.
But the question for us is duty, not foreseeability. I recognize that they get mushed together, particularly in my head. But the question for us is the legal question of duty. So I actually would ask you to go back to Justice Johnson's question and assume that they were both students, but assume that they were graduate students, law students, unlike Ms. Barlow, and assume that they were older and assume that they were from an urban background.
Your Honor, you can't divorce the duty question from foreseeability.
Well,
it's a fundamental aspect.
There's a legal question for us, whereas foreseeability is and proximate cause are going to go to the jury.
Foreseeability is the limiting principle for any liability that would flow from any duty. It's a fundamental aspect of any tort analysis. It has to be part of the court's consideration.
Well, the question presented to us, as I understand it from the federal court, assumes foreseeability and asks us only about duty.
Well, the duty analysis is intimately bound up in the question of foreseeability. It has to be part of that analysis, just as special relationship is part of the duty analysis.
So duty at Starbucks, where the incident involved two students, older students, graduate students, from urban backgrounds, not rural backgrounds.
Your Honor, leaving aside Seattle University's,
Assume it's a public university.
let's assume that the regulations are the same. Washington State University's regulations provided for the application of its EP15 sexual misconduct policy off campus. Specifically, it's in the policy. It says that. It's disciplinary regulations, 504-26015, apply off campus.
So that sounds like an answer that duty depends on each individual school's regulations. And I think your approach would encourage schools to cut down a lot of their regulations.
I think if they tried to do that, Your Honor, they might run into problems. But let's look at what Washington State University undertook to do. Their own policy of their student code of conduct applied off campus. It applied temporally to the time period before classes, after classes. It applied to online conduct. It applied to foreign study. If a student went overseas, EP15 applied to Washington State University's students. It undertook to do that. And it undertook in this particular case, in these facts, and I know the court didn't want to get into these facts, but in these facts, it argued that its policy of student code of conduct applied to this off-campus set of circumstances.
So if that policy had not existed, going back to my question, is there a duty?
I think there still would have been a duty, but the fact of the matter is the university undertook to do that. It had no problem. And in the face of its argument, oh, the duty shouldn't apply off campus. Oh, this is such a terrible administrative burden. There's no such administrative burden. They're already administering a disciplinary system for off-campus conduct. And they undertook to do this themselves.
Mr. Talent, I think Justice Montoya Lewis has a question. She's patiently been trying to ask. It's a bit awkward.
It's tough to do this with a TV camera.
Let's give her our attention.
Certainly.
I just back to that question that Justice Gordon McLeod and I think Justice Johnson are asking that I don't think turn specifically on the facts or the policies that you're making reference to. The issue that I'm interested in and that I think my colleagues are trying to get a clearer answer from you about is even if there are those policies and so forth, and I think I can ask this question without really even focusing on these facts. If the university has no information that such a party, event, etc., is occurring, and people are having contact with one another, even though they're students, where would the university's authority lie for them to do any kind of intervention at the stage at which this party, as in this case, is ongoing? What is it that you're suggesting that the rule be with respect to the scope there?
I think very clearly in our briefing that the scope of the duty is coextensive with what the defendant has undertaken to do. It's no different than if I'm a business owner and I invite people on the premises. The scope of the invitation is really important.
Okay, so
that's a fundamental aspect of
back to this problem then, and I don't think it's as clear as you hope it is. If it gets back to the problem of if we say that it's the scope of what the university undertakes to do, and we say, okay, well, this person is on probation until they graduate. What it sounds like you're saying is don't put people on probation, don't intervene, and stay out of it. How do you deal with that?
Not at all. What we're saying is this is an additional tool to provide teeth to the policy that the university has allegedly undertaken. Washington State has this brave policy that says we're going to be very aggressive about stopping sexual violence, EP 15. It's incorporated it into the student code of conduct. It said we're going to do all this stuff. We're going to provide for some administrative discipline, and we're a closed community. We have the campus police. We have our staff that's communicating with these individuals. We can put people on probation, but then we are not responsible when something untoward happens by virtue of the very same person they put in the place to cause the problem, Mr. Culhane in this case.
In this case, counsel, either in your briefing or your opponent's briefing, probably based again on the case, we characterize the special relationship as being one of strict liability. Do you agree with that characterization? If not, what is the nature of the liability?
No, it's a regular kind of 315 restatement, 319 restatement, or restatement third 4041, protective duty as to an individual, or a take charge duty, or an amalgam thereof. It's tempered by the scope of the invitation or the nature of the relationship that the university's undertaken, subject to, and this is an important point in response to Justice Montoya Lewis's question, the point about foreseeability in response to Justice Gordon MacLeod. Foreseeability is vitally important here. If it was an individual about whom this was a surprise event, it had not been something that anybody could predict, it would be one thing. Mm-hmm. In this case, 3 prior incidents of sexual violence and an incident that occurred the night before the rape. This guy groped Madeline Barlow the night before the rape.
Well, counsel, what is it then that the university should have done under your theory? What could they have done? What should they have?
I guess what I don't understand is he's actually he's talking about evidentiary arguments that would have been made at trial, etc., right? You know, he's talking about the groping and the raping and all of this. They're here to talk about WSU's duty, right? Duty to control one of their students, i.e. the person who did the assaulting, right? And it's almost like he's still trying to argue his case, even though that's not what this is about, right? Is it horrible that the assault happened? Yes. Is it horrible that this girl was assaulted by this person and groped by this person? Yes. But they've already had their case for that. They've already had their opportunity to lay out their argument and their oral argument for that case. And it's my understanding that, in fact, it was found by the Supreme Court and by the Court of Appeals that WSU doesn't have control over a student or a faculty member regarding what they do off campus, right? You can't control what someone is going to do off campus, outside of business hours at all, right? I don't know how one could think that they would be in control or that they have a duty of care to monitor students outside of campus. Like, is that what they're trying to get at here? Know what I mean? Is this, I don't know what this guy's getting at, but it's interesting that he's still trying to argue like the actual assault when that's not the topic here.
What the university had, and this goes to breach, of course, Your Honor, but there are a whole bunch of things the university could have done. It could have foreclosed his ability to transfer from Vancouver to Pullman. It had the ability to put his registration on hold under its own regulations. 504, 26, 425, put him on hold. It could have conditioned his probation on a whole set of circumstances. It could have required him to do far more as conditions to his probation to allow him to stay at the university. They didn't do any of these things. They allowed him to transfer. And of course, we have the case, the Doe case.
Crazy too, that they let this dude transfer from the Vancouver campus to Pullman. Interesting, huh? Interesting. So a sexual assaulter, predator, groper was transferred to Pullman. Interesting. Where the WSU police officers on the Pullman campus are also groper, predator, assaulters. Interesting.
That we've cited to you that indicates that Louisiana has a specific policy that forecloses the transfer of people like Mr. Culhane from one campus to another in the university system when they're under suspicion or investigation for sexual misconduct. It could have done any of those things that would have stopped this from occurring. They didn't do any of this. They let this guy who was a predator go from Vancouver to Pullman to new hunting grounds, and he raped Madeline Barlow as a consequence.
And that's where the negligence comes into play. And you used the word, I don't think it's part of the question, but you used the word temporal, meaning time
Okay, sorry about that, guys. Literally everything crashed. Hang on. Don't worry. You know, it never fails. This is why I don't do lives, man. This is why you guys don't see me much. All right. Sometimes I feel like this shit is an actual waste of time. All right. Give me 1 second. I know it was going so good. But, you know, it is what it is, man. This is the story of my life over here, man. Doesn't matter what I do. It's always the fucking feds, mittens for kittens, these damn spooks. Don't worry, don't worry. I'm gonna bring it back up. Hang on. Give me 1 second, okay? Hold, please. Okay. All right, so we should be back now. Everything should be okay. Let's continue listening to this. So sorry about that, guys. I really am. So sorry.
All of these online, the policy. Washington State University defined the temporal scope of its responsibility to students in its own policy. And it's why we've argued that, in fact, like the scope of a business invitation, the fact of its own regulations is vitally important to the nature of the duty that would be found here.
Counsel, you are going well into your rebuttal.
I understand that. I was just winding up. Whether it's under the restatement second or the restatement third or this amalgam under CJC, we ask the court answer the first question yes, and answer the second question along the lines that I've described, that there is a duty under the protective obligation to Madeline, the take charge duty as Thomas Culhane, or an amalgamation thereof, subject to the traditional tort principles of foreseeability. Thank you.
Thank you, counsel. Response, please.
Chief Justice Gonzalez, and may it please the court. Kaylin Wett and Brian Baker on behalf of Washington State University. Sexual violence anywhere, anytime is intolerable, and Washington State University takes sexual violence seriously and works
after dealing with Washington State University, not anywhere or anywhere as you started. What is it that Washington State University did in regards to its relationship with its students that would have curtailed this problem? And my question comes from Restatement 315 A and B. Seems to me A pertains to the university's responsibility to Culhane, and B, its responsibility to Barlow. The university is the one that had control of the information and control of Culhane, and had avenues, as counsel was indicating, to address the issues it had with Culhane in regards to sexual offending. So what is it that the university do in regards to its duty to its students in regards to this arguably foreseeable harm that occurred?
Well, Washington State University is working pursuant to its existing duty under existing law regarding its students and enforcing its code of student conduct against Culhane's behavior off campus as well as on campus. So in this situation, after Culhane was adjudicated responsible for sexual misconduct, he was punished. He was punished proportional to that misconduct. So he was on probation. He was suspended from registering for classes until he completed the terms of his sanctions. He was required to write a probation paper. And that's important because in that paper, he was required to write about consent. And Mr. Jessel rejected his first attempt because it showed that he had an inadequate understanding of consent and had him rewrite it. He was also required to write a research paper about empathy, and he was required to undergo alcohol evaluation.
Those are appropriate in regards to sexual offending. And also, isn't it true that the university was aware in regards to the writing of the paper concerning consent that he had no clue what consent entailed, yet they transferred him to another location?
So timing's important there. At the time that Culhane put in his request for a transfer, he had not been adjudicated responsible for any misconduct. So his transfer was granted as a matter of course. And the university only uses sanctions that it has published in the WAC. And refusing a transfer wasn't a published sanction at that time. So that wasn't available. As to who decides what sanctions are appropriate, it depends on who the adjudicator is. And here it was a brief adjudication, and Mr. Jessel, who is the director of the Office of Student Conduct, determined those sanctions.
So when he was transferred, he was not, was not indicted, charged, found guilty, nothing of any sexual assault. So it's not like they knew, oh shit, we got all these reports, he's a sexual assaulter here on Vancouver campus, let's transfer him out to Pullman. When he was transferred to Pullman, there were no reports of sexual assault, which is why he was granted the transfer, okay? So let's just make that clear. It's not like Washington State University had all these reports of sexual assault at the Vancouver campus from this guy and then allowed him to transfer. She just clarified that he was transferred because when he applied for the transfer, he had no charges. There was no adjudication or anything on him at that point. Right turn, Clyde. Hello. Welcome on in.
Have changed over the years, though, and there's more emphasis on training and teaching. Now it would be a body that does the student conduct proceedings and requiring that they learn about various topics related to sexual misconduct.
He's indicated that there is not a special relationship between the university and these students. Could you explain that to us, please?
There is a special relationship while students are on campus, because the campus community is what the university can control. But when students leave campus, the university no longer has the ability to control who those students are exposed to and what they get up to, as the circumstances here. This was a party on a Saturday night. Ms. Barlow didn't ask permission to go to the party. Mr. Culhane didn't ask permission to have a party. The university police couldn't go to that party. University police couldn't stop Ms. Barlow from attending it. There's no jurisdiction. And when there's no control, there's typically no special relationship or a duty to protect or control in that situation.
I'd have to agree with her 100% on that. Right? It's not like these students go to the university and ask for permission to throw a party off campus. Right? These students don't ask for permission from the university to attend these parties off campus, right? So how would the university be in control of anything anyone does off campus? To me, it's a stupid argument. I'm not going to lie to you. Like, is sexual assault wrong? Of course it is. Should we, literally throw these fuckers in a wood chipper? Yes, that would be my solution. Okay. That would, I'm not condoning violence here. I'm not, I'm just saying. It's very interesting to me, the argument that people make that to try to sue a college, claiming that the college is in control of the student who commits the sexual assault. Well, then I would say if you're of the mindset that the college can control the students and have control of the students, then I would go even further to say that if the college has more control over their university police officers, if anything. WSU, as far as I know, I haven't seen any lawsuit against the retired and or resigned police officers who not only partook in the sexual assault and the grooming, but also helped cover it up. If WSU has control over anyone, it's those cops, not the students and what they're doing off campus. Just my opinion.
Stated you agree it's a special relationship under 315?
No, under Section 344 of the Restatement of Torts, the business invitee relationship.
So you don't agree, when Mr. Talmadge stood up and said there was no disagreement about a special relationship, I just had to ask, how do you envision that special relationship? Because I think what we're hearing here is Mr. Talmadge thinks that there should be a take charge relationship, for example, which is a very broad duty, and also the duty, almost a quasi in local parentis undertaking. So what is it how would you describe the underpinnings for the special relationship that you apparently agree exists?
So this court held in Nivens versus 7-Eleven that a business has a duty to its invitees. So it's premises liability. The business can control the university campus, and who has access to that, it can police it. The university here has a commissioned police force, but their jurisdiction is only as to campus. And the university can control who is admitted to its programs. So that special relationship, which is fully under the university's control, makes sense here and already applies, and we don't dispute that. But a 315A take charge duty would go too far because the university can sanction behavior after it occurs, but it doesn't have the ability to prevent behavior before it occurs.
Right. Like, what is WSU supposed to, what is this Minority Report, right? WSU is now, they need to track pre-crime, thought crime. Know what I mean? What you can't do anything until, someone's been charged or someone's been, you know what I'm saying? What is this? They want like Minority Report up in here, right? Thought crime. It's wild. So WSU is responsible for students and what they do, how to control them before they commit a crime.
A 315B duty wouldn't make sense because, this court just decided Turner last year. And under Turner, a person has to be essentially helpless and unable to manage their own safety in order for a 315B to apply. And university students are adults. They have their own agency and autonomy, and they can make their own decisions. So a 315B duty doesn't make sense.
Counsel, could you talk to if you know, are there statistics that tell us the average age or obviously the range can go from, 17 or 16 even to 85 or 90. But do we have any statistics that tell us, because, part of this is in local parentis. Are we using an underpinning that actually makes sense given the demographics and the statistics on the ages of students who attend? And not just, I don't think this is limited to university. It would be community colleges, I assume, any post-secondary educational institution.
So I do know that for Washington State University, the average age is about 24 because Washington State University has a number of graduate programs as well as undergraduate programs. Its population is about 30,000 students overall. As far as other universities, I'm not sure of those statistics, but community colleges are open admission. Anyone can attend a community college, and that is quite frequently a broad, diverse range of students. And so that age group is going to be very different.
James Moe and Beach Babe, hello, welcome on in.
Senior counsel, I did wonder about that age argument because some of the briefing says, these are adults. This is not like the K-12 school setting, but we do know in many university settings, there are a number of high school students who are attending in different programs. Is it your position that there would be a different analysis if we're dealing with, for example, a 16 or 17-year-old high school student? I think at many of the community colleges, or what were formerly called community colleges, on some campuses, a majority of the students are running start. So could you address that?
So I believe with students attending a running start program, the duty that the K-12 school district would owe them would still apply. But the university wouldn't have that same duty because it is not catering to these younger students. And with the K-12...
Could you explain what heavily marketing running start? And it is, of course, you'll recognize a premises responsibility, but typically those students are spending 100% of their time at the college, not the high school campus.
I think the expectations are different. So when parents send their children to a K-12 district school, the question this court has asked in those cases is, You know, at what point does the protective relationship, the protective duty that the parents have over the student go between the parent to the school and back again? And when a student is attending a community college or a university as part of Running Start, I don't think that expectation is there. I think parents understand that they're going to a community college campus with adult students there as well. And the expectations are different. It's not a K through 12 population, and it doesn't have the same K through 12 responsibilities.
That I started university at 16. Not from a high school program. I started university at 16. So are you saying the university had no duty to me in regards to my safety, considering that they have this policy that they mandate students participate in to address sexual assaults as well as consumption of alcohol? Because I'm not following that argument you just made to Justice Stevens.
So the university accepts that it has a duty to students for their on-campus conduct and any school-related activities they participate in. It's what happens off campus where there's no duty, where that wouldn't apply.
Correct. Because even if you're a 16-year-old student who manages to get into college early or whatever the case may be, and you're on campus for courses at 16, 17 years old, the college can only have a duty of care to you while you are on campus. Even if you are a 16 or 17-year-old minor on campus, the moment you leave campus and you decide to go to somebody else's off-campus home that you've been invited to for an off-campus party that the college hasn't approved, they didn't give permission for the party and they didn't give permission for you to go to the party, how is the college then responsible for what happens to you at that party? Whether you're 16 or 25 or whatever, right? It doesn't matter. They're not responsible for you at any age the moment that you are off campus. They can only control what's happening on campus. They cannot follow you around. What do you want? Do you want a security guard to follow you around off campus? Do you need a police officer to follow you everywhere you go off campus? Just to make sure? Do you get what I'm saying? It's really weird, the argument here. Jason, where'd the video go? You're only getting audio, friend. We're only getting audio. The video's linked in the description.
Let's take that to the next step. When the university imposes sanctions on an individual, as they did in this case, and that conduct occurs off campus involving one of the university's students, are you saying the university does not have a duty, especially since the university is the one with the knowledge of the conduct that is harmful? You're saying the university has no duty to the student, the other student victim, in regards to the student perpetrator for actions that are foreseeable from the conduct that they are overseeing?
Yes, Your Honor. Yes, Your Honor, I am, because knowledge and foreseeability have never been the only basis for the duty. With special relationships, there's also an aspect of control, either control over the potential victim or control over the potential perpetrator. And that's missing.
Control over the victim, the perpetrator, student perpetrator, in that they were monitoring and sanctioning certain conduct, one of which could have been put this person in a remote class setting. Another one could have been expel the student, which eventually happened. So the university did have that control over the student perpetrator and had the knowledge about that student perpetrator that was not disclosed or could not have been disclosed, arguably, to the student victim. So the university had options available in regards to its duty. There was a special relationship, don't you think?
No, not as to this off-campus behavior.
Mm-hmm.
Just because an entity has the ability to punish or sanction behavior after the fact, this court held under Honkoop that the ability to regulate behavior does not confer the requisite control to create a special relationship.
It was not after the fact, counsel. This individual was actively being supervised or sanctioned by the university. The university took current action in transferring this student perpetrator without that student addressing the harmful conduct?
Because, Your Honor, Justice Helen Whitener, she already explained to you when the perpetrator, the alleged perpetrator, was transferred, there was nothing on record for him at that point as being a sexual assaulter. She already clarified that.
So I'm not following your argument as to the locale. To me, since this university had the ability to control the conduct off campus, that duty did go beyond the confines of the campus. And what is the campus in today's educational system anyway?
Well, here the university had sanctioned the student for his previous misconduct, but the university sanctions can only go so far. And at the end of the day, it can expel a student. That is the extent of its power. It couldn't tell this particular student that he couldn't live in this particular location, or he couldn't have a party, or he couldn't have students over to it.
And in regards to this case, how important is age? Because we hear a lot about the age of the student, and as I've indicated, I was 16 attending university, so age in regards to the cases, you know, the high school cases dealing with local parentis, but age, how important is age? How important or relevant is consumption of alcohol? How important or relevant is gender? Because it seems to me those are red herrings in regards to the university's duty to its student, which in this case may very well amount to a special relationship that followed with certain responsibilities.
I don't believe that age or gender have any bearing on the special relationship, because the special relationship should be based on what the university can control, and it can control its campus, it can control its programs.
Correct.
But it can't.
You said premises liability before, but you also seem to be talking about school sanctioned events, which aren't necessarily on premises. So what's the liability there if it's not premises liability?
That would be the duty of reasonable care that this court recently discussed in Nord versus Seattle. So once an entity undertakes some event, it would have a duty to do so with reasonable care. And if that event, you know, potentially has foreseeable perpetrators at it, then you would expect that same reasonable care to apply.
Right. For anybody who doesn't know, sorry, because I know I had to take the video down. The video is linked in the description. If you need to see everyone's faces and see all the justices and blah, 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 go ahead and click the link in the description. This is Kaylin Watt, who is counsel for State of Washington. She is the counsel for Washington University. The one talking that you guys think sounds like Jennings, it's not Jennings.
The university could actually have some control over that event because, you know, just like in a dorm setting, the university can go in, can inspect the premises, can regulate visitation hours, can regulate whether it's co-ed housing or not, in a way that it just simply can't do that off campus.
Counsel, there's been a lot of discussion about the rules of conduct as some basis for the scope of whatever the duty might be. I think we are here to decide in the first instance, what the duty is, where does it arise from? But assuming that it's a premises liability, what is the interaction between the code of conduct and the duty imposed under that premises liability theory?
The code of conduct and previous sanctions would inform, you know, whether a particular harm was foreseeable or not. A duty already applies on campus. I don't know that it would go further to go off campus because, again, this is just a regulation. This is an ability to enforce access to the campus and the programs, and it doesn't go beyond that.
Oh, I guess you have 5 minutes, so let me pursue that. I thought you were done.
Please do.
So essentially, the code of conduct, which is rather broad and urges good behavior on all these levels, use of drugs, alcohol, consented to sexual conduct, and so on. If this had happened on campus and it was a sexual assault, or if this had happened as a result of, or maybe an injury that occurred arising out of overconsumption of alcohol, and it happened on school premises, and so we're looking at premises liability, would in your view, the university have responsibility or a duty then to prevent that harm to the student that it fell upon.
The duty would certainly exist if this harm occurred on campus, and then whether it was foreseeable harm and whether the university acted with reasonable care would be jury questions.
And then one last question, and I won't dominate anymore. But in your response about age, part of the underpinning for this argument, as I understand it from the plaintiff here, is based on this notion of local parentis. Age matters then, doesn't it, if that's the underpinning?
Right, so the in loco parentis duty applies until children reach the age of 18. Once they reach the age of 18, school attendance is no longer compulsory. So even a school district wouldn't have that same special relationship with the students.
Mm-hmm. Right.
So,
because once they're 18, they're an adult. You can't compel them to attend.
Running start students. That would be, if we found a special relationship based upon the in loco parentis theory, would it be limited then to students attending as running start students up until the point of 18? Is that how that would work?
Yes, if it was based on the in loco parentis theory, then once people reach the age of 18, they are now legally under the law adults and have all of the requirements that go along with that, and nobody has a protected relationship over them, unless and until they enter a business or step onto a bus or stay in a hotel.
Thank you.
Well, counsel, that's completely accurate because they can't rent a car until they're 25. There are all sorts of things in our own statutes that have a variety of age range triggers that are not 18. But I want to leave that aside for a second and clarify something I thought I heard you said. If this set of events in this case occurred on campus in a dorm, are you saying that you would conclude that WSU had liability?
Yes.
Not liability. Duty would apply because
they have a duty of care.
The school has a duty to its students on campus, and premises liability. And then it would become a question of whether the behavior was foreseeable and whether the university acted reasonably in those circumstances. And those would be questions of fact for a jury to determine.
How does the university have a duty to its students on campus, and the same knowledge that brought about that duty on campus somehow does not follow the student off campus with the same student duty that the university had control over? I'm not following how that duty somehow stopped.
How is the university supposed to follow a student off campus and control what they do? I'm not even trying to be mean. How do you expect a university to control a student and or a teacher's assistant and or faculty member with what they do off campus? Late hours. Right? I don't understand how she doesn't understand this. It's kind of what I'm getting at here.
Gates of the university's so-called campus.
So there's no other situation where we hold an institution liable for conduct that occurs outside the institution.
That's why we're here.
Right. So if a duty were to apply here to off-campus conduct, it would apply in other similar situations, like a church congregation with its members, where the church congregation, perhaps the pastor, has specialized knowledge about a member that would suggest they might be potentially dangerous to other members of the church. If there's a duty here, wouldn't there be a duty there to church members outside of the church setting or with the employee-employer relationship? That knowledge, if knowledge alone is sufficient to confer a duty, that's going to apply in various situations. The WSBA obtains knowledge that an attorney is violating the ethical standards, and that doesn't necessarily make the WSBA liable for conduct that occurs after an attorney has already been sanctioned.
Your time has expired, but please rise to rise to the request.
Thank you, Justice Gonzalez. This court should reject plaintiff's request to impose a special relationship between a university and students that would follow students off campus. Rather, this court should answer the Ninth Circuit certified questions by pointing to existing law, specifically Nivens versus 711, and the Restatement of Tort Section 344, which already defines the relationship and attendant duties a university has with its students on campus.
Thank you. Rebuttal, please.
Okay, here comes the rebuttal.
Several factual points, members of the court. First, the probation here was until this individual graduated. It wasn't limited in scope. Secondly, Madeline Barlow was a Running Start student at Clark College. She was on campus for 4 days at Washington State University, and that is the area of maximum concern, the so-called red zone that's been talked about. The first quarter of freshman year is the time period in which sexual violence occurs.
Well, counsel,
So he's saying that she was on campus for 4 days before this happened. But what he's leaving out, this is counsel for Madeline Barlow, Phil Talmadge. What he's leaving out is that all of this happened off campus at an off campus house. None of this happened on campus at all.
if we recognized your special relationship based on the mere relationship of being a student, it wouldn't be confined then to what you just described as the red zone, would it? It would extend to every student who has a relationship as being a student.
And I'm talking about the particularity, Your Honor, of these facts and why it's compelling in these circumstances for there to be a concern.
But are we deciding for one case, or are we deciding as a matter of law?
Precedent.
Broadly, of course, Your Honor, but in terms of NL, you have a liability in the K-12 system for off-campus behavior involving sexual violence to a student.
Which commenced on campus.
Which commenced on campus. And the circumstances we're talking about here commenced on campus because Thomas Culhane was subject to the responsibility of Washington State University to supervise him. And that's what's lost sight of in this.
Well, counsel, does it matter that that in the case involving the student who left campus, that it was a student who was mandated to be on the campus, that she was under the age of 18, she was a high school student, whereas in a university setting, there is no mandatory requirement of university?
All of those circumstances go to foreseeability. We don't know what the Bethel School District requirements were with respect to a student being on campus, based on the court's opinion in and out.
I'm not sure that's correct because we're looking at duty. What is the basis for a duty? Of course, in the K-12 setting, it's in loco parentis and based primarily on the mandatory nature of an education between K and 12. Isn't that correct? So don't we have to have a basis? We do, and we have the Student Code of Conduct, which is mandatory, Your Honor, not to be lost sight of. This Student Code of Conduct applied to Thomas Culhane, and Madeline Barlow was the beneficiary of it. She was to be protected by it. Counsel's notion that there can be a divorce between, we can discipline these students, but we have no responsibility to deal with them once we do discipline them and they are under probation and we supervise them, that the university can turn a blind eye to the reality of that and let this predator do what this predator did.
So under your analysis, the person assaulted doesn't have a cause of action if they're not also a student at the university.
That's correct. And that's the distinguishing feature that the Ninth Circuit noted in its opinion. It was the question that Justice Madsen posed about Johnson. Both university students, unlike Johnson, the university knew about Thomas Culhane, unlike Johnson, and the universities have undertaken this very extensive responsibility for the prevention of sexual violence on and off campus by their own regulations, disciplining students for that violation, all of which make Johnson an outlier in terms of what the law is.
Can I ask a question?
Hello, Lana, darling. Happy birthday to you. And thank you so much, honey. You did not have to do that. You did not have to do that. Mercy Cat, darling, thank you so much for gifting memberships. 5 of you turn green. Make sure you say thank you to Mercy Cat. There's only about 3 minutes left of this rebuttal here. And then we can close it out.
He's out of time.
Certainly. Thank you.
Yes, you are out of time. But I want to ask anyway.
That's it. You're right. Yeah.
Thank you. So again, I'm looking for the basis for this responsibility, this duty, And we agree that these are not mandatory educational institutions like a K through 12, but you've just said, no, the basis is the code of conduct. So is that the basis of for the special relationship, the code of conduct? Or are you advocating for a special relationship by the mere fact that one is a student at a post high school institution?
The answer to that question, Your Honor, is the notion of special relationship, contrary to what counsel has argued, is not confined to control and custody. Rather, special relationship, HBH indicated this, involves the entrustment of one's safety to another. Madeline Barlow's safety was entrusted to Washington State University. Her parents didn't expect that she was going to be a victim of sexual violence as a condition to going to Washington State University.
So it's not because of the code of conduct?
No one expects that they're going to be a victim of sexual assault when they go to a university. But most adults, and believe me, this is no shade towards this victim whatsoever. None. What this guy did, he is a piece of shit. They should chuck him in a wood chipper. And that's just my opinion. But the fact of the matter is, if you choose to violate code of conduct and you choose as an adult to take yourself off campus to an off-campus house where there's partying, drinking alcohol, people are doing drugs, at that point, as an adult, you are the one who is responsible for your safety, not the campus. The campus has no control over you, nor do they have any control over your offender, because both of you have violated code of conduct and you've taken your actions off campus. You chose to go do things off campus that you know you can't do on campus, is all I'm saying here. Okay. Holy shit. Karmic retribution, toes. Hello. Welcome in, everybody. I'm going to come over to chat once this is done. It's like a minute and a half.
Code of conduct measures and confirms the scope of the invitation to Madeline Barlow and the scope of what she could expect.
So it's because of the code of conduct.
Well, it's just like the business invitee or landlord tenant. Special relationship is conditioned on the scope of the invitation, the scope of the undertaking. And Washington State University had a scope of the undertaking of its duty to students like Barlow to protect her from students like Culhane. That's the answer to the question on special relationship.
In my opinion, WSU has more of a duty that should have been to protect these victims from the WSU police officers who groom and assault them. That's who WSU has control over, their own police officers. They don't have control over a student and what they do off campus.
Special relationship has always been of that nature. You limit the scope of the special relationship to the scope of what the defendant undertook to do. Special relationship, landlord, tenant, or anything else. Thank you, Your Honor.
Yes, you may briefly summarize the relief you request before you sit down.
Our request was yes to the first question, and with respect to the second question, to adopt a protective duty under Restatement 2nd, Section 315, Restatement 3rd, Section 40, a take charge type duty, which was as to Culhane under 319 or 41, or some combination thereof, as the court did in CJC, subject to traditional principles of tort foreseeability. Thank you.
Thank you to both counsel for your arguments as well as your briefing. We're going to take a 10-minute recess and we'll come out to hear the second case.
All right.
Okay.